Hello, a very warm welcome to the BPA Associates Community First Podcast, where we have legal and social conversations with our community. This podcast has been running for a year, and our main aim is to provide substantive, quality information for members of the community. It is hoped that these members of the community who listen to us will be empowered with the knowledge to be able to protect themselves and indeed have a familiar knowledge of the law and conventions that pertains in our country. My name is Adelaide Benneh Prempeh. I'm BPA Associates Managing Partner. And today we have a very special guest in our midst in the person of Justice Kweku Tawiah Ackaah-Boafo, a Justice of the Court of Appeal of Ghana. You're warmly welcome, Justice Ackaah-Boafo.
Thank you very much.
To the platform. And indeed, I'm extremely delighted you could make it, because we have had cause to reflect over the past year on what we've been trying to achieve. We've had a variety of topics ranging from domestic violence, wills, pensions, and the like. And it all leads down to access to justice, because that's what we are trying to achieve for our listeners. Many a time we come across clients who, for one reason or the other, cannot access legal representation and attempt to do things on their own. And when things fall apart, they then come to lawyers and say that lawyers are expensive. So on this special occasion, indeed the first episode for this year, we thought we'll pause for a moment and consider access to justice. Now, we know that's very multi-dimensional. There are so many aspects to it that we can't possibly discuss it in detail, but we are hoping to zone in on a very minor aspect of it, and focus on the unrepresented litigant. So bridging that civil gap. Before we embark on it, I think it's only fair that I attempt a very abridged version of your resume. Now, your lordship has several accolades to his name, and I think that the profile he's provided for our social media pages doesn't do him justice, but I'll give you the headlines, dear listeners. Beyond being the Justice of the Court of Appeal, your lordship is a barrister and solicitor of the Supreme Court of Ghana. He's a barrister, solicitor, and notary of Ontario, Canada. He has a master's degree to his name, and indeed he came up as the best overall student in another program that he embarked upon in GIMPA. So you see that he's very brainy and very pleasant as well, if I may add. Your lordship, beyond his judicial functions, also serves on a number of committees. One important committee, which I know will create a buzz with our listeners, is the E-Justice Committee, where the mainstay is to digitize judgments of our judges in Ghana. He also serves as a faculty member of the Judicial Training Institute, and the Ghana School of Law is blessed to have your lordship as a part-time lecturer where he teaches advocacy and legal ethics. Among some of his areas are civil and criminal procedure law, intellectual property law, human rights law. So there's no better person to do justice to this topic than your lordship, Mr. Justice Kweku Ackaah-Boafo. So before we start delving into what we're hoping to achieve in terms of unrepresented litigants in this conversation, we all have different ideas of what access to justice means. As a lawyer, when I think access to justice, I immediately think of access to competent, knowledgeable lawyers. But your lordship has a very unique role as an administrator of justice, and therefore I'll throw it to your lordship, if I may, what the concept of access to justice means to you.
Thank you very much, Adelaide, and thank you for the opportunity to play this role, a role which is to help educate the Ghanaian citizen. I mean, the concept of access to justice basically is an element of, it's a central theme in the promotion of the rule of law. And access to justice, to my mind, is the ability of that individual to be able to seek and obtain remedies through the institutions of justice in our country. And if one to look at it, it reflects the idea that justice should not be for the privileged few, that everybody who is a citizen or even a visitor in Ghana, if you have an issue, you should be able to contact a lawyer or have the opportunity to access our courts or the judicial system. This access to justice, again, I would say is a fundamental principle that emphasizes the fact that individuals, when they have challenges, it may be civil litigation, it may be in any area of the law. You mentioned intellectual property. Let's look at that young man who may have had an idea that he has put out there that someone want to take away. So that individual should have the right to go to court to say that, look, I am entitled to some protection with regards to this my idea. So that is how I'll look at access to justice. It's a concept which is rooted in the belief that everyone, and I emphasize everyone, should have the opportunity to seek and obtain justice regardless of one's background. It has many facets, and here it may include legal education, what you are doing, letting people know what are their rights when it comes to any issue that they are confronted with. So lawyers having the opportunity to go out there and to explain. In many jurisdictions, before you even renew your license, you must have some hours of pro bono work that you've done. So that is giving people the opportunity to access justice. Access to justice, to my mind, will also include affordability. How affordable is it for an individual to seek the help of a lawyer, for instance? And if it is that expensive, that is what will bring us to the main topic, self-representation. The Americans will say proxy into being. Also the fairness. Fairness should also be a central theme in access to justice. And here we are talking about a legal system which is fair, which is transparent, and which is accessible. Again, we are using the word accessible because it includes, do we have legal procedures which are simplified such that an individual may be able to read through it and say that I understand it and I should be able to fill this form to get what I want. It also includes legal aid, such that government may have an institution where we may have lawyers paid by government, so that those who financially are not in a position to access justice by hiring private citizens by way of private lawyers would go through legal aid for their matters to be dealt with, that they are not paying from their pocket. It also includes, I'm using the word include when I'm going to use inclusivity. Because inclusivity is also very much important, because in every society we may have people who are vulnerable. And here in every society, you may talk about women, we may talk about children, we may talk about people who for some reason are the margins of society. But when we say we have a good legal system which is inclusive, such individuals should have the opportunity to access it. So that's how I look at that concept in brief.
That's really fantastic, and I think that our listeners will benefit a whole lot from that response. And whilst you were speaking, I was thinking about the various reasons why people decide to represent themselves. One cannot ignore the financial aspect, that a lawyer is far too expensive, so they wouldn't even attempt to go and engage the services of a lawyer. Although in fairness, there are various kinds of lawyers, and the test really is who is competent to raise that. So from what you have outlined, it appears that those are the sort of reasons that people come to court representing themselves. But in our modern day, there are other reasons. One cannot ignore the fact that everybody seems to get responses via Google, where they sit down and type in what they think the issue is, and then a diagnosis is produced through Google. But what I suppose people fail to realize is that when they do that, they get the diagnosis, but they don't understand the know-how and the skill set for legal representation. So in your experience, do you come across people who are not represented, can afford it, but they think they know the answer, so they've turned up a court, ready to fight?
Yes, so you have many reasons why people self-represent themselves. As I said earlier, the Americans will call it a proxy. People who just decide that they want to represent themselves.
Yes.
And there are many myriad of reasons for this. First, clearly, is the cost involved. Yes. The cost of hiring a lawyer can be very expensive. And it's not only in Ghana, everywhere. Lawyers can be very expensive. So that individuals may not have the financial ability to retain counsel. In societies where they have legal aid, some individuals may qualify for legal aid certificate, for instance, and every society will have a threshold. I mean, from my experience as a practitioner in Toronto, anyone who earned less than, at the time, $12,000 a year will be eligible for legal aid. But the question is, what is the subject matter?
Yes.
So you may meet the financial criteria, but the subject matter of what you're dealing with a mortgage issue. No.
Yeah.
Go and sell your house to litigate. So people may qualify for legal aid, and there are others as well who financial earning is like that they don't qualify.
Of course.
But
yes.
what they make is also not enough to retain counsel.
Yeah.
Because a person earns $15,000, which means that he's cut off from legal aid. But the $15,000 a year also will not give the person the opportunity to retain private counsel.
So it's a catch-22.
Exactly.
Yeah.
So the person may end up representing him or herself. There are others who I call the amateur lawyers.
Yes.
They are those who may have just some knowledge in law, because the person may have studied some contract law, commercial law at a college, and may assume that I know law.
Yes.
So I want to represent myself. And as they say, little knowledge can be very dangerous. So he studied this and studied one or two legal principles. And such people believe that they are confident enough to represent themselves.
Run with it.
Yes, but in reality, they will always face a challenge because of procedure. Others also, for some reason, believe that they want to handle matters their own way. And I'll give you an example. When I practiced in Toronto, one of the things one would observe is when people wanted to sponsor family members in area of immigration law. And they will tell you, but this is just filling the forms. So they'll just go and fill the form, submit it, the application will be denied because some basic questions were not answered properly.
Then they come looking for a lawyer.
And then they come looking for a lawyer. By the time you take the record, you see that this was poorly done.
Yeah.
And my response to such people was always, you see, if I'm driving a car and my car is not functioning, I don't go to Canadian Tire, buy tools to go and fix it myself.
No.
I have to go to the person who can do it, because that individual may have the knowledge. But for some reason, some individuals may think that they can handle their own matters.
Yes.
There's also the reason of people not trusting lawyers.
It's a big problem.
Yes.
Yeah.
Somebody may have had an experience, and the experience is such bad that I don't want to call another lawyer.
Yeah.
I don't want to call another lawyer.
They're all bad.
Yes.
Let's get on with it.
Exactly. So the idea of not trusting lawyers, not trusting the profession, will make them decide to self-represent themselves. There's also the issue of lack of accessibility. I think in Ghana, we all think there are many lawyers, but they are all housed here in Accra. You may go to a whole region, let me cite the Western North. If you go to the Western North region, it's a region. Yeah. And I'm not sure you find more than 5 lawyers in the whole region who are based there.
That is true.
Yes, that so lack of accessibility is
also an issue.
It's also an issue.
Yes.
And these are some of the reasons which will make people decide to represent themselves. Also, when people are not comfortable to tell anybody about their problem, they think that I will go and tell the judge in the court. I don't want to
directly.
Yes.
Yes.
Forgetting that once they are in court, they may have to speak out publicly.
Yeah.
But they do not feel comfortable to share this idea with anyone.
Yes.
Okay, so these are some of the reasons why people may decide to represent themselves. Even though I think it is important to note and to let people be aware that when you make that choice to self-represent yourself, know there are challenges that you will face.
Of course.
Because you don't understand the procedure. Court rules are procedural rules. And the court will not bend over because you are not represented. Okay, so people need to understand this. If you are in a position to retain counsel, make sure that at least you have a lawyer to represent you. But if you make that choice to represent yourself,
then you're going all the way.
Exactly, you're going all the way.
So you get to the deep sea, and then you don't know what to do. So
when I was at the trial court, let me tell you, I was at the trial court and I had this matter where both plaintiff and defendant were not represented. So plaintiff filed the writ, defense has filed defense, then the plaintiff filed a reply, then the defendant filed reply to reply, and then they continue to file.
Oh dear.
I'm like, when are we ending? No, but what he filed, he said something that I need to respond. I said,
boy. No. Yeah.
That's
it's glaringly obvious how it can go very wrong.
Exactly,
because they have no idea of law and procedure. It's their day in court. They are here to fight it out, and therefore will fight to the bitter end, as it were.
Yes.
So I guess from what you're saying, Your Lordship, we'll never see the end of unrepresented litigants. They are going to turn up at court, whether it's suitable or not. I mean, is there a particular position of the law when it comes to self-representation in court? For example, as a lawyer, as you know, we're bound by legal professional rules. And if you're going to engage with an unrepresented person, there are ways that you should conduct yourself, making sure that they realize that you're not there to represent them, but you're representing your client, going as far as advising them to seek counsel, independent legal representation. What happens in court as the referee, you being the administrator of justice, the impartial one? One party is represented, another is unrepresented. What happens in court? Is there a particular way of doing things?
Okay, so just before I answer the question, let me quickly say that in regards to the position of the law and unrepresented persons in court, the Constitution by Article 19, the 1992 Constitution, which is the foundation of our laws in this country, recognize that when somebody, for example, is charged with a criminal offense, the person may choose to self-represent himself without a lawyer.
Of course, yes.
What the law says is that, but the person should be afforded all the opportunities to provide a good answer and defense. Our Supreme Court has interpreted that article in the Ackaah-Boafo case, which has led to the disclosure regime in our country. So the prosecution may give you the disclosure as to whether or not you can read and understand and represent yourself.
That's a different matter.
Yes. You know, the civil procedure rules recognize that people may, I think it's Order 2, Rule 5.1, speak to the fact that you may file a suit in your name and self-represent yourself. So the rule is such that you have the opportunity to do it.
Yeah.
If you look at Order 1, Rule 3.2, it speaks of if you are self-representing yourself and you cannot be there, a family member can be there for you to represent you. But they only come to stand in your stead in court. So you have to do it yourself. Now, all this show that the law recognizes that you have the right to represent yourself. If you go to the US, I think their Sixth Amendment actually make it so clear that you can make a defense, you can make a choice to self-represent yourself even in a criminal matter. And their Supreme Court has interpreted that to mean that you have the right and the court should give you the opportunity to represent yourself, but you must understand the procedure. Now, in terms of, in regards to what a judge must do, as a referee, a judge must be very careful that you don't become the lawyer of the litigant who is self-representing himself. What it means is that the judge must be very careful whilst explaining the procedure, because if you look at, I think, the guidelines for judges and magistrates in regards to the bench book, it says that a judge or magistrate should ensure as far as possible that procedural fairness is afforded to all parties, not the self-represented, to all parties.
Yes.
So where you are not represented and someone has a lawyer, all that the judge ought to do is that the process is fair. The guidelines also says that a judge or magistrate should inform the litigant in person, that is a self-represented, of the manner in which the trial is to proceed, the order of calling witnesses, and the right which he or she has to cross-examine the witnesses. So the judge would also have to explain to the self-represented litigant any procedure relevant to the litigation. So all the judge is to do is to give you a general advice of the procedure.
Yes.
But as to how you do it, you have to do it yourself.
So in other words, the judge shows you the path, but you have to walk it on your
Absolutely.
own. Yes.
Absolutely.
Which doesn't resolve the issue for you.
If your adversary is represented by a lawyer and the lawyer is taking advantage to bully you, the judge will have to step in.
Exactly.
But as to how you do your cross-examination, it's up to you.
Yes.
It's up to you.
I think it's very important, this distinction that you've drawn. Unrepresented persons, when they are taking that decision to go to court and do it on their own, have this belief, albeit misguided somewhat, to the fact that if they turn up and there's a judge there, the judge will help them, give them a helping hand.
Yes.
So 2 for the price of 1. I get the judge and I get a lawyer as well, because invariably judges tend to be lawyers. It's very important they realize that, yes, the judge will be there to support the process ensuing, but they are not your lawyer, and they are not there to represent you.
Yes, actually, the bank book, interesting, says where in the interest of justice and the circumstance of the case requires that a judge draw a litigant's attention, the judge may draw attention to the law applied in the court to the litigant.
Yes.
The judge may show you how to question witnesses. The judge may identify applications available. Somebody may have filed an injunction. He said, well, you have the chance to oppose it. But the judge will not draft your affidavit for you. And the judge will also suggest to you the procedure. Well, the witness that you are calling, you have to lead the witness to testify, or the witness ought to file a witness statement, and the opponent will have to cross-examine. So the procedure the judge would explain. As you said, he show you the path, but as to how you walk on that path is your choice.
And you end up probably being a little bit more overwhelmed than when you started, because a lot more information is coming at you without the necessary support to understand it by way of legal services. So that leads me to the issue of challenges. As a lawyer, when I am up against unrepresented litigant, it's always very challenging, because you're starting very much on the back foot. There's an element of mistrust, because why are you talking to me when you're not representing me? You can't get it right. Whatever you say is not right. And they always think that, oh, well, hang on, are they trying to pull the wool over my eyes here? Why is he being so nice? They are oblivious to our code of conduct, which tells us to be, fair and to advise you properly to get a lawyer, or indeed realize that I am not here for you and such. So they always think we have a hidden agenda. And that in itself can be challenging and cause sometimes delay in the entire process, because they are not prepared to work with you, putting it loosely. So, as a judge, what are some of the challenges you face based on what you've discussed already as to the law and the procedure and showing them the way, as it were? What sort of challenges do self-represented litigants face on a regular basis?
I think the challenges are many. The first thing, as I said, is when a self-represented person is to cross-examine a witness. I mean, clearly, the person doesn't even understand
Indeed.
what to ask. And
that is true, actually.
I read appeal record recently.
Yeah.
It was a criminal matter, and these individuals had gone to a young man's home, basically disarmed him, stole his items, his electronic gadgets, put it in his car, and drove away. The car had a tracking device, so he was able to quickly inform his employer, and an hour or so after, they were arrested in his car and were all charged with robbery, and they were self-representing themselves. If you read appeal record, so somebody will ask a question like, you said I came to your house. What shirt was I wearing? And then the person goes, well, you were wearing the dress you were arrested with because you left my home. It was what? It was white. And you go, you are lying. I was wearing green.
Oh my goodness.
And you ask yourself,
the potential is enormous.
Exactly. So cross-examination is a big challenge. Also, it takes a very long time for a self-represented person even to examine a witness.
Yes.
Okay, so because they are unable to identify which is relevant and what is not relevant.
Yeah.
I mean, they want to ask every question. They also tend to interject a lot even when people are speaking. So they may have led the witness, somebody's cross-examining them, they ask a question, the witness may answer a question, and he is just holding the hand. No, I didn't say that.
No sense of procedure.
Exactly, no sense of procedure.
Yeah.
And the truth is, every court has its procedural rules.
Yes.
When you are self-representing yourself, and especially when the other side has a lawyer, you may end up losing the case, sometimes even on technical grounds.
Of course.
You didn't file your process on time. The court made an order for you to do something, you didn't do it. On the day of hearing, that is when you are filing your process. And a lawyer may raise an objection that the judge may have no option than to concede and to strike out your case. You see, so another challenge is self-represented litigant can be very abusive.
Yes.
They're abusive to everybody, and you highlighted that in your question. They don't trust the lawyer, they don't trust the judge, they don't trust anybody.
Yeah.
So when you are explaining the process, they rather become angry and they can be very abusive. I mean, you see situations where after court, they just go and attack the lawyer outside the courtroom, that you are blaming.
Yeah.
And when you award costs, they will tell you, I won't pay because all of you are biased against me. So the challenges are very
It's
many,
a minefield. I mean, even for lawyers, litigation can be stressful in the best of times, but we have that restraint and training to realize what it is and keep that emotional distance. But with a self-represented person, you open up a whole can of worms of the emotions. It's unfamiliar, it's complex, and they just feel out of sorts sometimes. So I think from what you're saying, it's very important that if one is thinking of embarking on this self-representation journey, they realize it's not a walk in the park.
No.
And that perhaps making efforts to seek legal representation, at least for part of the process, may be useful, so that you know that you are protected somewhat when it comes to the law and procedure and the knowledge of it. Are these barriers that can ever be overcome? I mean, what do you do from your experience as a trial judge when it's all going up in flames for self-represented clients, for example? Do you normally have any techniques to try and steer them away off the dangerous path without coming across as partial?
These two individuals I told you about, filing reply to reply and reply to reply. I mean, at a stage, I realized that there was no way we were going to be able to proceed with it. Mm-mm. So I referred both of them to legal aid. They go to legal aid.
Yeah.
I think somebody there should be able to.
This is true. Yeah.
They both went, but the report I got was one of them said he's experienced enough to handle his own matter. He doesn't need legal aid. The other person retained counsel through legal aid. Mm-hmm. Okay, but so we're still faced with the same challenge, because this person, who in his mind thinks that he's able to represent himself, came back with the same attitude.
Yes.
I think that the way forward is, if for some reason we've given many reasons why people make that choice. You are in a situation where you cannot just afford a lawyer. There's no legal aid available to you. If you're to make that choice, at least have somebody who has the knowledge to guide you. Or come and sit in the courtroom. See how people are doing it, the lawyers. Maybe you may be able to learn something out of it.
As law students are encouraged to do,
exactly.
actually.
And
yes.
It's one thing that I think that going forward, maybe our law school should think of having a legal clinic, as it exists in many jurisdictions.
Yes.
So that law students can help such individuals to draft their process, and then may be able to guide them through it. Okay, but I think the main reason why we find many of these things is a question of emotion. I spoke about them being abusive.
Definitely.
People losing their sense of reason. They are emotional.
Yes.
And especially if it is a case of spousal relationship. Everybody seems to have lost his sense of reason.
That is true.
So they just can't agree.
Yes.
Yeah, but for a judge, the line is so thin that you may be accused of descending into an arena of conflict.
Definitely.
By being the other side's lawyer.
Yeah.
So the best I can do is to advise you that, look, you are at a stage where you may need someone to help you.
Yes.
If you make the choice to continue to proceed on your own, I will. But chances are that you're going down.
It won't go well. Yes. I'm quite glad that you said that you've actually had the opportunity to refer a case to legal aid, which means that it's functional and it works. Mm-hmm. Is it something that beyond legal aid, are there other organizations that get involved in helping unrepresented litigants? As a judge, were you familiar with referring cases or indeed cases coming to your court from legal aid and similar organizations?
I think that in this jurisdiction, the legal aid is the only institution you can make reference to.
Good.
That people may go to legal aid and lawyers may come in to help them out. I know some law firms basically have also started doing pro bono work.
Yes.
Where they will just listen to your story and they are of the view that, look, you need our help.
Yes.
And they will be willing to help you. Mm-hmm. So I think that going forward is something that the Ghana Bar ought to look at.
Yes.
Individual lawyers ought to look at and just set out some time out for pro bono to help people.
Yes.
We know of FIDA, we know of WELDF.
Of course.
These are all institutions which are there, but as their name imply, they will usually come in to assist vulnerable women and children. I don't know of any organization that may help a poor man.
We need to look at that.
Exactly.
We've had the opportunity to work with WELDF, and it's definitely focused on women and their needs.
Exactly.
So perhaps we need a level playing field in terms of that. Yes.
It's interesting because our constitution by Article 294 speak directly about legal aid. I think in recent times there has been a lot of improvements because I understand that they've recently hired many lawyers to the legal aid office in Accra and other regions. So people can then assess that. But as far back as 1980, the great Justice Taylor, sitting in the Boligatanga courts, in a case called Pekoro and Another versus the Republic. So these are individuals who say we were given fertilizer to cross the border to Upper Volta and give it to a farmer who is Ghanaian to help in his farm. And they were arrested by border guards, charged with corruption and smuggling. They were in court, they pled guilty with explanation. Honestly, if you listen to the explanation, they were basically saying they were not guilty. But the court found them guilty and sentenced them. On appeal, the prosecution said they couldn't contest the appeal. But they made a suggestion that there ought to be a retrial. And this was at a time that these individuals had already spent 7 months in jail. And Justice Taylor, in not ordering a retrial, made a statement which was more of an obiter. But he said, be that as it may, it seems to me that in order to safeguard the liberty of the citizens, in whose interest the laws of the Republic are promulgated, it is essential that indigent and illiterate persons, ignorant of the legal process, and accused of serious crimes carrying harsh penalties, are not left to their own devices, but are assigned learned counsel by way of legal aid. This was in 1980, I'm sure around 1979-80, but it's reported in the 1980 Ghana Law Report. So even at the time, there was that thinking that, look, people need help when they are in a legal situation, especially when somebody is facing criminal charges.
Definitely.
So I think that the Constitution speaks of legal aid. Both government and institutions, stakeholders ought to take that.
To rise up and take that opportunity.
Take up that opportunity to help.
There are not enough workers in the vineyard, as we say. And I think that it's quite rightly the case that if we're talking about liberty, one has to have that opportunity as a basic human right. Even with civil matters, if you stand to pay some serious compensation, one has to make sure that at the very least they have some support. And it's good you mention legal aid, because what it then means is that if you have an issue, you can approach the Legal Aid Services Commission offices and seek at least initial consultation to say, where am I? Or indeed seek support for drafting purposes. If that at least is sorted out, then you can consider whether your case can go through mediation or go to court. But at least there is some help at hand if you are qualified. You are assessed by legal aid.
And I think that I'm sure many judges will agree with me, that it's frustrating when you have self-represented litigants in your courts.
Indeed.
And especially when one side is represented. Because as I said, the line is so thin. In your attempt to explain the procedure to this person,
you have the other side eyeing you.
That, why are you trying to be this individual's lawyer?
I can imagine.
And they may leave sometimes after court. They want to talk to the client. Can I talk to the judge? I want him to explain this. No. He only explained it to you when he was in the courtroom. In
everybody's hearing.
Exactly.
I'm not your next best friend.
Exactly.
So it's very important.
Yeah.
So thank you so much, Your Lordship. I mean, in this world of AI and technology, one cannot escape that issue. I mean, in your view, what role, if any, does AI or indeed technology have, if at all, in empowering self-represented litigants? Any scope for that?
Yes, I think technology can play a significant role in helping people who are self-representing themselves. I mean, first of all, we know through technology we can access information. So an individual who makes that choice to self-represent him or herself, if the person is technologically knowledgeable, you can get that information that you need. But be careful using AI to assess Ghanaian, let's say, court system.
Yes.
When there may not be much information there, may give you information that may not be, reliable in regards to your matter in a Ghanaian court. Okay, but we can also have technology where some lawyers, I spoke about lawyers making pro bono part of their practice.
Yes.
I think that through technology, you may have lawyers platform where somebody will say that for this community, for those who can access, every week I'm willing to do a 30-minute education on how to file process, let's say, at the district courts. So the lawyer may not have to travel anywhere. In the comfort of his or her office, if the individual can access it through technology, the person may be able to learn. Now, most people spend hours on social media. And I think in that respect, even the judiciary can have a platform where basic education can be given. When you go to, I think it used to be the case, there were pamphlets in the courts.
Yes.
Yes. People could just pick and just study to find out.
Even with other jurisdictions.
Exactly.
Yes.
That is how you file your process. Now, instead of the pamphlet, you can have a platform that such information can be provided for people to access it. Technology can also be used when it comes to language barrier. Okay, because see a self-represented person who may not speak the language of the courts. There may be interpreters in the courts, but if this individual can access technology such that the legal civil procedure rules are being explained in the key language to that individual before he even files it, explaining that process to that individual may the person come to the realization that I don't think I can do it by myself. I think from the way it's explained, I cannot do it.
So they do a bit of groundwork
exactly
before they embark on it. Yes.
So yes, we can all leverage technology to help with that desire for people to access justice in the country.
Yes.
Through government agencies, through the judiciary, through private individuals and lawyers. I think that technology really has a role to play.
This is such a brilliant response because it's loaded with a lot of nuggets. And what I like about that is that we can all do something. We all have a role to play. Yeah. I think before COVID hit, we were all technology shy and we thought, how can we survive without moving from A to B on a regular basis? But I think COVID has taught us that technology can make us even more efficient. Yes. And if you sell it that way of 30 minutes of your time per month or so, just churn out some kind of how to do X, and for a community at large, then it's a way of empowering all of us. And you're right, once you realize what you're up against as an unrepresented or potential unrepresented litigant, you say, well, okay, this is something that I cannot do. Yes. So let me try and get some, a more competitively priced lawyer or indeed somebody who's well-versed in the law to work me through it. Let me go to legal aid and get the initial documentation or processes sorted out. So you have basically passed the buck to all of us, Your Lordship, that we can't sit there and say this is an insurmountable problem. Let's all get up and doing. And I think that it gives certainly, and I'm sure it gives our listeners cause for thought that we are all in this together. We can't just talk about the problem without coming up with solutions. So what do you think the future holds then? All things being equal, what does the future hold for, in our current legal system, for the unrepresented litigant?
I think that, and this will be linked to my last answer.
Yes.
Ghana's judicial system has seen some reforms over a period. It started off with the specialized courts, where we had, because I'm sure in the past, when you heard of the courts and the high court, it was a high court. Then we had a specialized court. Yes. We had the labor division, commercial division, land division. Now we have the e-justice. we have the e-filing. Okay, these are all reforms which are helping our judiciary to move forward. One reform, for example, is also taking evidence through video conferencing.
Indeed.
You don't have to travel from Sydney, Australia to come to testify in Ghana. For the self-represented, clearly, people will need to understand that we cannot have a pluralistic system where we have a system for those who are represented by lawyers and those who are not. It doesn't happen anywhere.
Yes.
The best that can be done is to simplify the procedure for you. The court system is such a conservative institution, such that the judge must take the evidence either through written documentation or hearing you orally. What it means is that there must be procedure for it. So whilst reforms are taking place, it's important that we end up simplifying some of our rules so that those who are, because we cannot take out the fact that some individuals at all times will self-represent themselves.
Yes.
That district court at Prestia, where there is no resident lawyer, many people who will go to court will self-represent themselves. So I think that as we think of reforms, we should think of simplifying some of these rules. In other jurisdictions, that is what they call the small claims court.
Yes.
The rules there are so simple that people do not necessarily need to have lawyers to file their claims. So I think that is one area that, as we think of reforms with the self-represented individuals in mind, we may have to look at.
Do you think we'll have to get rid of the Latin in our judgments?
Absolutely. I think that, but even now, I think for many of us,
we're watering it down.
Yes, we're watering it down.
Yes.
The wheretofore, the King James words, I think we should all be encouraged to write plain, simple English.
Indeed.
For people to understand.
It's the most effective, actually.
Yes.
Well, Your Lordship, I am absolutely delighted you were able to make it, because even I have learned so much, and thank you so much for breaking down these elements of it. I mean, my key takeaway is the fact that, yes, you always have self-representation in the system, but as a self-represented litigant or a potential one has to not take this decision lightly. You have to weigh the pros and cons and hopefully access resources that might be able to assist you on the journey.
Yes.
But if at all possible, get some legal expertise to break down the knowledge and the skills, and don't get yourself at sea so deep that you can't retreat when it's too late. Do you have any concluding remarks for us? I don't want to take too much of your time. If you leave it to me, I'll sit with you for another hour.
Well, what I will say is that we are talking about our self-representation, but you also touch on the issue of reforms. I think the world we've gotten to a stage in our world so that every nation is doing well to digitize their system and to have things move on smoothly.
Indeed.
So my comment is to the fact that government ought to be involved with the e-justice system of our judicial system. Because you see, when it is well done, there are many things that we can do to save costs.
Indeed.
I'll give you one example. Many years ago, when I used to practice in Toronto, a Ghanaian lawyer visited me, and I took him to video courts. And it was experience for this person to see that the judge is sitting in the courtroom, the video is being to a jail, and they will appear. Say on the video, can you mention your name?
Yeah.
Mention his name. Do you have a lawyer? Legal aid counsel is in court. Well, he's represented by Mr. So and so. He's brought a letter that he's waiting for disclosure. Matter should be adjourned for 2 weeks. When disclosure is ready, counsel should communicate that with lawyer. The truth is, Imagine us every day transporting people from Nsawam to court. If our e-justice, if our digitalization has gone so well, these are things that we can do. We won't have people in remand who have been there and everybody has forgotten about them. Mm-hmm. Because they don't have to travel to court.
It'll be very efficient.
Very efficient, and the system will certainly benefit. Because at all times, I think we need to be aware of the fact that by Article 125, justice in our nation emanates from the citizen. It is for the citizen.
Indeed.
And therefore, in everything that we do, we need to do it in such a way that it will be to the benefit of Ghanaians.
Thank you so much, Your Lordship. Our dear listeners, this has been Adelaide Benneh Prempeh hosting the BPA Associates Community First Podcast with a very special guest, Justice Kweku Tawiah Ackaah-Boafo, who has educated us today, been very gracious with his time, and I hope that we will be able to entice him to come back on another occasion. Thank you very much, and keep listening to us. Have a good day.